This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, Attorney Stuart M. Address.
Good morning to everybody within distance of my voice, and I am told that is pretty far.
That's the entire world.
And maybe even beyond that. I know we reached Jupiter.
Yes, that's so true.
And then again, men are from Venus, women from Mars, and
Oh, don't go there.
Don't
Martian. Go there.
I'm a Martian that always seems to marry Venusians. I love doing this to the station manager. Anyway, before we get into our little chit-chat, Cliff, on his preceding show, Swap Shop, he says that he's not really here. It's his evil twin. I would like to confirm that. Cliff is not here. It is definitely his evil twin.
Oh, yes.
That proves I listen.
There you go.
The other thing Cliff said that struck me as I was driving in today was that he has the phone numbers of everybody who's ever called going back 26 years. I think Cliff is a secret agent of the CIA or the NSA.
No, it's Russian.
Oh, you mean the KGB or the GRU?
Whatever they call themselves now. Yeah, that's
SILLY.
SILLY is right.
TRUMP.
Oh.
SUPPORTERS.
Oh. Ooh.
All right, so Cliff is right about one thing. You can call us here at 340-1590. You can change your names. You can be anonymous. The names will be changed to protect the innocent or the guilty, depending upon how it works out. Cliff was talking about, anonymity. Well, you can call and tell me you're asking for a friend. It's sort of like that advertisement for a little blue pill.
Yes. I'm just picking these up for a friend.
Yeah, that's right. Just call. You're asking. Something. We get a lot of calls in our office, actually, where they're calling for a friend. Most of the time, we suspect that that's not exactly true. Sometimes it actually is. So call for a friend. That's okay. We'll try to help you best we can anyway at 340-1590. Last thing I want to say is, following this show, Ask a Rabbi will be a best of. Rabbi Loeb is not in Florida, I believe, at the moment, unless her flight is later. Rabbi Loeb is on her way to Arizona to accept her second doctorate. Dr. Rabbi Loeb will return next Friday with a doctorate in psychology. So if you call her, be prepared to be analyzed. That's all I'm saying.
I'm analyzed every Friday.
She analyzes me every time I talk to her.
What are you talking about?
What can I tell you?
Oh, man.
But anyway, on behalf of Ask a Lawyer and Congregation H. Client, which just turned 4, we'll be having a birthday party next Friday at 7:30. I'd like to wish Dr. Rabbi Loeb congratulations. Safe travels there. Safe travels back. And tonight you'll be included in the Go Mail blessing.
Cool. Well,
right.
As I jokingly said last week, it's now Dr. Rabbi.
Well, Dr. Rabbi, that's right. That reminds me of Dr. Mr. MD.
Yes.
Okay, but she's not an MD. She's a PhD. PhD squared.
That's it. MD's coming next.
Who knows? With her, you never know. She is a dynamo. She puts me to shame the hours she works. So who knows? She could become a medical doctor and be one-stop shopping.
I was kidding her when we were talking about religions of the world. I would love to to take her course on IRSC.
I would actually be interested, if I can find the time, in auditing the course, or at least just going to sit in.
Me too, yeah.
Because I do think that even though I cannot agree with her on what a day means in the Old Testament, when God created the earth in 6 days and on the seventh day he rested, even though she and I have massive theological dispute on that, one would think that she has the inside track on the answer. I disagree. But she has amazing teaching skills. She listens to her students. She listens to her congregants. She's responsive. I watched her once at IRSC. I wouldn't mind sitting in on a whole class because I think that you could probably learn a heck of a lot from her.
Yeah, and we all know that on the seventh day you went to a Dodger game.
Excuse me, the Mets.
Oh yeah, we're the Mets station.
The Mets,
I'm sorry. This is
the Mets
going
were
back
playing
a
in
few
heaven before he decided to send them to the Polo Grounds in '62, and then to Shea, and now Citi Field. Don't you forget it.
Okay. Yeah. God created the Mets in Flushing.
Well,
New
that's
York.
true, and that's a little bit weird. And I actually lived there for a bit.
Cliff's got a note. I can't even read it.
Neither can I.
I can't.
It's amazing. We're 10 minutes in. I haven't said anything about law.
Oh, there we go. Okay.
All right,
Yes.
so if we're going to start on law, we're going to start a little bit more on Title VII of the Civil Rights Act, which covers discrimination. And we're going to talk just a little bit about sexual orientation. Now, we're not talking about transgender or transsexuals. We did that a few weeks ago. We're talking here about sexual orientation, which is basically homosexual, lesbian, gay, however you want to characterize it, and whether or not sexual orientation is protected against discrimination under Title VII of the Civil Rights Act and under the Florida Civil Rights Act, which for the most part follows the federal law in terms of what it will and will not protect.
Now, wait a minute. Doesn't federal law supersede all state laws?
Oh, no, Kimosabe.
Whoa! Okay, well.
No, federal law only supersedes state law when Congress has explicitly indicated that there is a reason to have a national policy that governs all the states and indicates in the act that it is exercising its powers under the Supremacy Clause. And even then, a state can enact a law which provides more protection than Congress has provided.
Wow. Okay. Yeah.
But not less.
Okay.
Unless Congress has exercises its powers under the Supremacy Clause, the states are free to create whatever laws they want as long as they're constitutional, even if they provide less remedy or relief than Congress has under federal law. This is why abortion laws are so different, capital punishment laws are so different. Everything, for the most part, is so different. And before we get into what is alike, we have Norm on line one. Hello, Norm.
Hi. I spoke to you a while back. My motorhome was destroyed in Irma.
I do seem to recall that, yes.
And I've been battling with the insurance company.
Oh, I know what that's like.
Yeah, I was paying for a policy of $90,000, the premium on that.
Okay.
And they turned me on when they finally totaled it. And they says, "Oh, we got you. It's less."
Right. So
Now
your $90,000 coverage on your mobile home was the maximum coverage.
It's a drivable motorhome.
Right. Yes.
It's one of those Prevost. I don't know if you know what they are.
Yeah. For insurance purposes, doesn't matter that much. I mean, I think
Yeah,
I know where you're going.
Okay, so they finally deemed it a
Total loss.
and they sent me a letter saying $56,000 and $785.
And that's based upon depreciation, right?
Yeah, basically they says, but if you send me more bills and you maintained it, basically it is a standing offer of $56,785.
All right. So you have a standing offer of $56,000 and change on a $90,000 policy, and they've indicated that if you have additional bills and all, and if you maintained it well and you can demonstrate that they may increase the number, but that number of $56,000 is based upon, depending upon the type of policy you had, depreciation.
Okay, yeah. On these motorhomes, there's no blue book.
Right. There's no traditional blue book, but there are sources that they go to determine valuation of even drivable motorhomes.
Yeah. Okay, so I got one appraisal for $89,000.
Okay.
I had another appraisal from California. It was between $70,000 and $75,000, and he says, "Well, he's out of state and he hasn't seen the vehicle." But I said, I sent all the pictures and bills and everything.
Okay.
He's uncredible. He's not credible.
All right. Well, they don't want to take the out-of-state $75,000 estimate, but you still say you had an $89,000 estimate from in-state, right?
Right. Yeah. So I got another. Another appraiser. Drove all the way up to Sanford. He looked at it and he appraised it between 80 and 85.
Okay, good. So you're both of the in-state appraisers are above 80.
Right. So they turned around and said he's uncredible. So they sent another appraiser. I met him up there, and I asked him. He didn't even know. He thought I was appraising it to get an insurance policy.
Right.
So he comes up and he appraises it over a year later, and the condition that it was in. He appraised it. Well, he told my appraiser, because they tried to mediate it between my appraiser and his. He told him he valued it at $55,000.
Okay.
As it stands right then and there.
So where is the insurance company right now?
Wait, I'll let you really laugh. So I wound up with the head of the insurance catastrophe.
Okay.
And he turned around and says, "Well, $52,000."
Now you're going in the wrong direction there.
I said that, and he says, "Well, I don't know nothing about that price." He said, "Let me check." So he goes and checks, and I had settled with them for $1,000 of personal stuff that was on.
Okay.
The coach. They told me that was a separate part of the policy.
It is.
And they paid me my $1,000. He took that $1,000 and added it to the 52. He took the tax, added it to the
Norm, I have to move you along a little bit. What are they currently offering?
Oh, right now they're suing me.
They're suing you?
Yeah, I got to go to meet the judge. And,
what are they suing you for? I can see you suing them.
Well, they say because I won't take it. They want it for me.
Okay, they're suing for declaratory judgment that the amount they've offered you is fair and reasonable, and to require you to accept it since you're holding out. And what you should be doing, hopefully with a lawyer, is filing a counterclaim against them and asserting that the reasonable value is predicated upon the two in-state experts that you got appraisals from and that actually saw the vehicle. So that will enjoin you in battle, which is probably where I thought you were going anyway, between the 50-whatever thousand and your between 80 and 89. And ultimately, I bet you there's going to be a settlement, not a trial. All right, but now you're in the litigation process. I don't know when you were served, but...
Yeah, I got to be there August 2nd.
You got to be there for what?
I guess the judge ordered me to take it. Oh, the three.
No. Well, you got to be there for what? I'm a lawyer. I'm concerned about that.
I don't have the papers. I'm pulled over.
Well, when were you served? When were you served? How long ago?
The 8th.
The 8th. So the 28th is not a date I would think you'd have to be there. Under normal things in circuit civil, the 28th, which would be 20 days after you were served, is the deadline for you to file a response to the complaint. Okay, you sure there's an order for you to be there or an order to respond?
Well, the order was to respond. I didn't respond to them. And
all right, listen to me, buddy. Listen to me. Listen to me, Norm. Whatever you do, at the very least, you send in a one-sentence letter to the clerk saying, I request more time to respond and seek an attorney. Do not let that deadline pass. They will enter a default against you, and it's harder to get a default vacated than to just follow the rules. So
I went personally to the clerk of the court. They couldn't help me. They said
they can't help you. They're not going to give you legal advice. That's what I'm here for.
Yeah.
I'm telling you, send a letter to the clerk with a copy on the summons that gives the plaintiff's attorney's address. Send a letter to the clerk. Make sure you send it in a way that's provable that you sent it, or hand deliver it, and send a copy to the plaintiff's attorney just saying, I request a 20-day extension so I can look for an attorney. It's automatically granted the first time you ask for an extension. But you've got to respond by the deadline. You don't want to have a default entered against you. And then you've got to get an attorney. Where are you located?
In Fort Pierce.
Oh, well, if you want to call
call
Cheryl, give Cheryl a call.
I talked to an attorney, a couple of them, and
Okay.
they want 30%, 33%.
Well, that's pretty standard, unfortunately. Unless you're willing to pay an attorney hourly, and sometimes hourly works out to your benefit, and sometimes hourly works out to the attorney's benefit. But you should be given the option in most situations. I
spoke to one attorney. He says, go down there on that date, August 2nd, and speak to the judge.
No. I'm sorry. I don't have the document in front of me, but I've done this for 33 years. I'm pretty sure that document is a summons. The summons means you respond in writing, not you go there. Okay? If you want, call Cheryl, send in that document. We can at least take a look at it. But if it's what I think it is, and I'm pretty sure it is a summons that was served on you along with a complaint, then your deadline is to respond in writing to the complaint, and you can get extra time by simply one sentence.
Yeah, they also sent me a letter after that to be in the court at August 2nd.
Well, I personally, as a lawyer, I can't comment on that then. I'd need to see the order, because that is very odd to me.
Oh, okay.
So if you want, give Cheryl a call at 781-8003, or, again, feel free to call any other lawyer, if you want in Fort Pierce, but talk to somebody today because it's Friday.
Okay, thank you.
You're welcome. Good luck, Norm.
Wow.
Okay.
That's quite a disparaging between 89 and
it is,
55.
and you get into litigation over that, and I have a family member who has a similar situation that had a flood, and the initial offer is way below what it would cost to fix the house. This is the game that is played. The game of all insurance companies is deny coverage or offer less, and most people, or a lot of people, will just finally fall by the wayside and give up because of the frustration and the aggravation and the time it takes. In fact, folks, if you were listening last Friday to the show, I discussed my personal situation with the Blue Cross and Blue Shield of good old Florida, in terms of my own eating disorder and their refusal to cover me, and then they're covering me day by day, 3 days at a time, and the fact that ultimately there will be a lawsuit. But yes, insurance companies are there to make profit. That's the name of the game. And if they can get you to give up, they've succeeded. And I'm sorry, that sounds unfair. Maybe there are some insurance companies that are better than others, but they're all there to make a profit.
But cutting them in half seems absurd.
It does, and I don't know where they get their numbers, and that's what, if you can't resolve that pre-suit, that's what a suit is for. And I suspect it will be settled, but this is a perfect example before you even go into the sexual orientation. Do not ignore legal papers. Ever. Don't. Consider that one of the few black and white laws that I'll ever espouse, because law is mostly gray. Don't let a default get entered against you. Okay, if you move to vacate a default within a short period of time, it'll be vacated. But if a default's entered, the next step, if they're fast enough, will be a default judgment. A default judgment has different rules. It is not as easy to vacate a default judgment. Don't let a default get entered against you ever. If you get served with a summons and complaint, no matter how frustrating, no matter how anxiety-inducing, it's sort of like getting a letter from the IRS. Do not shove your head in the sand. Call a lawyer. Get a lawyer. At the very least, by the deadline, make sure you respond with a request for more time, which in Circuit Civil, it's always granted the initial request. Especially if it's, I want more time to try to find a lawyer. You ask for 20 or 30 days. The clerk is authorized to grant those things. It doesn't even go to a judge. So don't ever ignore legal papers, please. I've had too many people come to me. I had a case about 2 months ago where I was trying to vacate a default judgment eviction, and I had excellent grounds to do so, and we had a great 2-hour hearing, and I really thought I had presented all the elements necessary to vacate that default judgment. Judge refused to do it. And I told my client, you can either live with it or you can appeal it. It costs more money. Don't ignore legal papers. If that's the message for today, I hope that's the message that gets out. It's not a good idea. Even if you say to yourself, I'm judgment proof, they can't get anything from me. Don't ignore it. A judgment's good for 20 years. If some money comes to you or you get a great job, they're going to be coming after you. Don't ignore it.
So Trump said he's judgment proof.
And with that, we have John on line 1 from Port St. Lucie. Hello, John.
Good morning, my favorite lawyer.
Oh, well, I love to hear that. Thank you very much. How can I help you?
This is the guy with the Yiddish cup.
Hey, the guy with the Yiddish cup. Shalom.
Well, Shalom Aleichem.
Lechem Shalom would be the Arabic response.
I'm calling for a friend.
A friend. Okay.
Actually, here's the story.
All right.
A fellow I've known for years. He was messing with drugs for many years, in and out of jail. Turned his life around. He's working, but he owes a lot of money, I guess, for the incarcerations, for the court costs and such. And of course, he can't get a license until he pays it.
Right.
And it's like $6,000. Is there any way around that?
Well, for that, I would have to say you would need to talk to a criminal defense attorney who would better know if there are circumstances under which you can either eliminate or reduce monies that are owed to the jail facility, typically, or the courts, for fees and fines and all that. I know bankruptcy won't do it because they're preferred creditors and it won't wipe it out. But whether or not there are some mechanisms where something can be done, that is something I would recommend you call a criminal defense attorney about, because they would really be the ones to know.
Okay, thank you.
You're very welcome. Yeah. Go ahead.
I have to drive, so I don't want to talk anymore. But what I wanted to ask you is, last week I thought you said you were going to talk about relationships.
We are. I'm going to do that today if I get to it.
Okay. All right.
All right.
Thanks a lot. Talk to you next
Thank
Friday.
you, John. Take care. Bye-bye. Well, folks, it's always nice to hear that I'm somebody's favorite lawyer, because I tell you, it's not always the case, even when you try to do your best for them. Sometimes you can't do you do your best, but you can't really get a good result, or you can't get a great result, or even in the case of consultations in my office with prospective clients, sometimes they walk out frustrated.
And you don't get that response from your ex either.
Well, I hope everybody understood that gibberish. We won't discuss my ex on the radio, because anything I say can and usually goes against me in a court of law. I have the right to an attorney. If I cannot afford that right, tough luck.
You are so bad.
I'm very bad. I'm very good, but I'm very bad.
Oh, it's funny.
Every so often, we had somebody earlier this week, honestly, that walked out before the consultation was over, frustrated. You can't help me. You won't help me. And, it's difficult. I mean, I spoke with Cheryl after the woman left, and, I tried to tell her, I want to help you, but the problem was she was talking about things that, she was telling me the minutia of how many times the blinds were open and closed when I'm trying to get to the basis of a cause of action and trying to determine the elements of a cause of action to see if there is one. And I tried to redirect her several times, but the woman kept going to minutia that, I'm hearing about how the landlord is mean to her, 6 years ago, and I guess I tried to redirect her one time too many, and I hear, well, you don't even want to listen to me. So I said, all right, tell you what, I'm trying to do this for a reason, but if you think I don't want to listen to you, I don't want you to leave that way, so I'm just going to sit back. I'm not going to ask any more questions. Tell me what you want to tell me. And I listened to about 20 minutes of things that made very little sense. And I said to her, I can't help you with any of that. I'm trying to find out if you have this claim or that claim, and she left. It's unfortunate. Sometimes that happens.
I was going to say, how many people do you get that are like that?
Very few, actually. That I walk out of a consultation before it's over. I think she's the only one. Some have left, unhappy, and you can tell they're unhappy. Sometimes they're unhappy with the advice I've given as to what their legal remedies are or are not. And sometimes, honestly, I can tell they're leaving unhappy with me. You can't please everybody. I try. I try to affect a bedside manner that is, at least in my office, I don't go to work in a suit anymore, and I love not doing that. In my big firms, I always had to. I go to work, in slacks and, button-down shirt, and I think most of the people I deal with come in and are put more at ease by seeing a lawyer like that than dressed in this, suit and stuffy. And there are exceptions. If I hear a bank president is coming in for a consult, I'm coming in a suit. Okay? I try to read my audience. But for the most part, I'm a little bit more laid back. And, when they're in the office, depending upon what they're there for and whether it's solemn or a legal case, but something that you don't have to, pretend you're at a funeral over, I will try to, as the Yiddish word is kibitz, to develop a rapport. Because in the end, even if I tell this person, I think you have an excellent claim for X, and I'm willing to represent you, what do you want to do? The only way they're going to say yes is if they feel comfortable with me. Any attorney, any doctor, anybody. A plumber comes to your house and you don't trust him, you're not going to hire him. The same goes for attorneys. There are plenty of, I hear this all the time, there are plenty of people that, don't hire an attorney or hire an attorney and then are unhappy with the attorney because they don't feel any connection. They don't feel the attorney cares at all. They're just a number or whatever. And I understand that, and it's one of the reasons I do a solo practice. I'm told I'm at least somebody's favorite attorney. Thank you very much, Teresa. And I was in 200 attorney firms. I know what that's like. We have a message from Rabbi, which it disappeared from my screen really quickly. So don't mind, I'm going to just open up my phone and see whether she said something like, I didn't leave yet. Or the rabbi just said, thanks, you're welcome. I know thanks is todah in Hebrew. I'm not sure about you're welcome, Rabbi. So I decided after being in 200 attorney firms in, my mother says I'm her favorite too. That doesn't count, nobody cares. After being in 200 attorney firms, in New Jersey before I came down to Florida, that wasn't for me anymore. Too much bureaucracy, too little control over my client interactions. So I came here, I was with 12 attorneys and 2 attorneys. Now it's 1 attorney, it's me. which means I make the decisions, and if something goes wrong, it's my responsibility. Something goes right, it's my success, along with my paralegal, of course. I know I'd hear something if I didn't say that, but it's true. And I like to try to have a rapport with my clients where at least they feel whatever happens, I fought, I cared, and hopefully we get a good result. I'd like to say most of the time I do, but not always.
Well, you want to feel like you're being represented and somebody's taking your case seriously.
That's right. And I do know that, John had just asked about the parenting stuff, and I have a funny feeling we're not getting there today. But let me go back into sexual orientation under Title VII. And it's interesting that the Department of Labor, the Second Circuit Court of Appeals, the Seventh Circuit Court of Appeals, they say that Title VII protects sexual orientation within the concept of gender-based discrimination. To me, that makes eminent sense. I mean, gender is male-female. If you're male and you're gay and you're being castigated because of it, that seems to be gender-based discrimination. Same thing, reverse it if you're female. So the Department of Labor came out with an opinion letter that said, yes, for all these reasons, we consider sexual orientation as within gender, and we view it as protected under Title VII. The Second Circuit, which is New York and a few other states, Seventh Circuit, not quite sure off the top of my head where that is, agrees. The 11th Circuit, our lovely Circuit Court of Appeals, says no. Sexual orientation is not protected under Title VII.
Where is that circuit? Miami?
Well, we're Florida, Georgia. It's located in Atlanta.
Okay.
Florida, Georgia, and I think there is one other state.
Must be the Carolinas somewhere, I would imagine.
Probably. It's funny, some of these circuits also either include Hawaii or Puerto Rico or Guam.
There you go.
I don't think we have one of those. In New Jersey we did. I don't think so here. Anyway, the 11th Circuit in 2018, just over a year ago on July 18th, 2018, in a case called Bostock versus Clayton County Board of Commissioners, held, and I quote, Title VII prohibits employers from discriminating against employees on the basis of their sex. This circuit has previously held that discharge for homosexuality is not prohibited by Title VII. We specifically rejected the argument that the Supreme Court precedent in Onkale versus Sundower Offshore Services from 1998, and Price Waterhouse versus Hopkins from 1989, supported a cause of action for sexual orientation discrimination under Title VII, end quote. So, if I try to sue under Title VII here in Florida, I'm not only not going to lose, the case may be dismissed outright. If not, it'll probably be summary judgment out. And under current law, an attorney can move against me for sanctions because the law is very clear. Now, there are exceptions to everything. If I can argue that the law should be modified, extended, what have you, and I have a good faith basis to do so, like arguing what all the other circuits are saying, I'm probably not going to get sanctioned. But at the district court level, I'm going to lose, because the only one who can change the 11th Circuit law is the 11th Circuit or the Supreme Court. So now, of interest, it should be to everybody, the Supreme Court has agreed to resolve the conflict within the circuits within the United States.
Good.
So that eventually, maybe next term, the Supreme Court will enter an opinion that declares sexual orientation is or is not protected under Title VII of the Civil Rights Act. From what I understand, the case could come up before the Supreme Court anytime between October of this year and April of 2020.
So what if they decide not to hear it?
Oh, no, they are hearing it. They've agreed to hear it.
Okay, but what if they don't do anything?
They will do something.
Okay, they have to do something.
If they hear the case, there's only 3 things they can, well, there are 4 things. No, there's 9 justices now, so they can't have a tie. There's 3 things they can do. They could not decide and remand it back to the lower court with instructions, and later on it typically comes back. Or they're going to vote yes or no. On a case like this, it's going to be most likely a 5-4 decision. I'm not saying automatically the conservatives will win and sexual orientation will not be protected. Very often, you'll be surprised that one of the so-called conservative justices will look at precedent and side with the so-called 4 liberal justices, and you have a 5-4 decision going the other way. That's what everybody is hoping, well, not everybody, but that's what the supporters of pro-choice are hoping on Roe versus Wade, that the projected death of Roe versus Wade by a 5-4 decision will not actually be the death of Roe versus Wade, but maybe even go 5-4 the other way. Or the decisions that the Supreme Court are going to be deciding will not reverse Roe versus Wade, at least not yet, but maybe more narrowly cut into abortion rights. So, at least with regard to sexual orientation, the Supreme Court's going to make a decision next term. And that will be it for a long time. You know, if there's a new justice appointed, let's say by a Democratic president, because somebody passes and let's say it's one of the conservatives, you might have a new majority and a case may make its way back to the Supreme Court yet again. Now, that doesn't mean it's automatically reversed because the Supreme Court does look at its own precedent and tries not to overrule its own precedent automatically just because you got new justices. That's the doctrine of stare decisis, Latin. But it means a lot to the Supreme Court because if the Supreme Court is not to be viewed as a political branch of government where decisions change based upon the whim of a new justice, we got two new ones now, then you have to look very carefully at the history of precedent. How firm is the precedent? How strong is the precedent? Before, even if you believe it should be reversed or overturned, before you vote to do so.
Okay, why does a case take so long in front of them? I mean, they don't have that many cases, right?
Oh, but let me tell you something. They may not accept very many cases per term. But what typically happens is very complicated, very work intensive. You know, they're going to first have an initial conference on a case.
That's all of them?
All of them. All 9 sit in a conference room without their law clerks. They're all alone for this initial conference. And the way it works is there is a summary of the case provided, which all the justices know because they have it right in front of them. And then the most junior justice, the newest one, gives his or her opinion, and they continue around the table with the newest ones going first until the Chief Justice gives the last opinion. The reason for that is they don't want the older justices in terms of service to giving their opinions first, influencing the newer ones.
Sway the new guys. Oh, okay, gotcha.
Okay?
Yeah.
So then you have this initial conference, and you have a rough, it's 6-3, it's 5-4. Sometimes if it's 4-4 and the Chief Justice is going to go the other way, he will assign the decision to himself, or her, well, not right now, himself, so that he can take first crack at fashioning what will hopefully be a majority opinion. Very often, all the justices write opinions. The Chief Justice will, assign the initial opinion to another justice that looks like they're going to be in the majority. Majorities change in the Supreme Court. A first draft is prepared by that justice. It's circulated among all other 8 justices. The law clerks now are busily working based upon what their justice has told them to research. Their justice then sends memos about the opinion to all the other justices, arguing their perspective. And another draft of the opinion comes out. supposedly trying to take in, either they're persuaded or they're going to incorporate a part of some of the comments of the other justices, because you want as few concurring or dissenting opinions as possible.
It sounds like that would take months.
It does. That's why. Then a third draft. And now if it looks like the court has shifted, what was the majority is now the minority, the opinion gets reassigned to somebody who is now, looks like they're in the majority. And until all 9 justices say, even if we disagree, we're done with our input on your opinion, we're either going to adopt it, we're going to write our own concurring or dissenting opinion, but we're done trying to influence the majority opinion. That's when you get a decision. And that is why it takes so long. And honestly, this is not an area where people should be upset that it takes so long. It is, in my view, even though I may not like some of the politics as I perceive them to be of some of the justices, the Supreme Court, in my view, is still the one branch of government that is the least political and is designed to be the least political. They are designed to try to truly do justice, and that means people of different perspectives, philosophies, original intent, the Constitution of Living and Breathing document, they clash. But there is an effort, there always has been, that those clashes are done with civility, collegiality, not disgust, animosity like Congress and the executive. And I think if they were to adopt more of the Supreme Court way of handling things, we might actually get more done. But the Supreme Court tries very hard, even if I vehemently disagree with you, my fellow justice. We're going to go have lunch together. We're going to play racquetball. We're not going to talk about it. We're not going to make this personal, because we may have to be on the bench together for 40 years. We can't let it be personal.
I remember seeing a 60-minute piece. The elder justice, I can't think of her name right now.
Ruth Bader Ginsburg, RBG.
Yeah, Ginsburg.
The
Yeah,
notorious RBG.
RBG. Yeah, and
it was decided and announced. I will live as long as necessary until there's a Democrat in the White House.
Yes.
And want to know something? I believe her.
She might. Yes, but that piece that they did with she and Scalia being best friends and they're always together and stuff. And you think, really? Okay, well, they seem to be on opposite sides. But just the other night, she was at a function, and she talked about the 2 new justices being very decent and honorable people.
And I believe her. In terms of people, I believe her. In terms of their philosophies, they are completely diametrically opposed to my philosophies.
And probably hers.
And hers, absolutely. They might agree on maritime law. They're not going to agree on civil rights. They're not going to agree on all the questions of the day. They'll find little areas where they happen to agree, on a patent infringement matter, But they're going to try to work together and persuade each other where they can. And if they become enemies, they'll never persuade each other in the future. It doesn't work that way. And if it starts, the Chief Justice typically, if he's running a good court, one day if she's running a good court, will step in and make sure that these two learn to play in the sandbox. Because you can't have, animosity with 9 people trying to make decisions that affect the entire country. And so it does take a long time, and I think that's because the Supreme Court truly tries to do the right thing, even if, as a lawyer, I hear of opinions every year, every session, and I say to myself, WTF? How the heck? I can disagree vehemently, but with very few exceptions, I at least believe they tried.
Okay. That sounds good,
and
yeah.
Honestly, and I can get a ton of calls on this, I don't know. Gore versus Bush in 2000 is a travesty to the court because everybody knows it was a political decision, and it tarnished, even some of the justices at the time indicate, it tarnished the credibility of the Supreme Court. Because essentially, one person elected the President of the United States. And I don't know what's worse, Russia interfering or one justice electing the President. But that came out of their philosophies. I don't think it came out of animus or corruption. It came out of a fundamental belief in how the Constitution is to be applied, how the ballot recounts, the law. I don't agree with it, and I think that even the court recognized that a 5-4 decision on that case is not what should have happened. They should have been working until they had a 9-0 or an 8-1 or a 7-2 at worst, because that's the only thing that gives credibility to the country. The Supreme Court has historically, on issues of serious societal importance, fought before issuing an opinion to grab justices over to their side, at least adopting portions of the majority opinion, so that the opinion can at least be 7-2.
Is it true that you hear that Justice Thomas doesn't write many opinions? Is that a true story?
Well, what I've heard about Justice Thomas, with an exception this year actually, is that he never asks a question during oral arguments.
Maybe that's what it was. Okay,
he broke his silence of I don't know how many years they said it was this year to ask several questions in one case during oral arguments. And I think probably the attorney who got that question was in shock, not anticipating what types of questions Justice Thomas might ask, because Justice Thomas doesn't ask questions. Whether that is going to continue or he's going to revert back to his silence. Justice Thomas has said he does not believe oral argument is generally helpful. That from the briefs and from the record, you can come to a decision in the case. That the arguments of counsel for 30 minutes are not likely to shift the opinion of a justice. I have always disagreed about the importance of oral argument. I think that a justice who's focused on something and is properly redirected might be influenced and persuaded. I'd like to believe that, otherwise oral arguments are a waste of time everywhere. So obviously the other 8 disagree on that regard with Justice Thomas. We'll see if he starts to ask more questions now.
That's interesting, huh?
All right, so given the fact that in the 11th Circuit sexual orientation is not protected, we have to wait and see what happens, and depending upon where you are on the political spectrum, hope that the decision comes down one way or the other. Obviously, I firmly believe that sexual orientation, transgender, all these things should be considered as protected under Title VII of the Civil Rights Act, because the goal of Title VII is to protect those who are in one way or another minorities and who can be oppressed easily. I think this certainly falls within that categorization. And I may not, I may not agree with all the rights that, gay or transgender people think they should be entitled to. I have some issues myself, but generally when it comes to the concept of civil rights, I do agree. Where I may have little issues is on the margins. All right, so to try to, at least in 4 minutes, finish up this topic. There is a burden shifting now in the 11th Circuit on all Title VII cases, which is very important. Typically, it was the plaintiff has the burden to start and show a prima facie case. The defense then has a burden to introduce a legitimate non-discriminatory reason for its action, whether it was firing, whatever it was. Then the plaintiff has the burden to prove that that legitimate non-discriminatory reason was a pretext. It's an excuse. It's not real. That is historically considered the McDonnell-Douglas burden-shifting framework. the 11th Circuit a few years ago modified this and are what are called mixed motive cases, which is very important. And the 11th Circuit, the case was Quigg versus Thomas in 2016. And the 11th Circuit said that in cases where the employer asserts a legitimate non-discriminatory reason, the employee can only rebut by showing that both a legitimate and a non-legitimate reason played a role in whatever happened, like being fired or demoted. If you only show that the non-discriminatory reason played a role, but not the legitimate, you lose. If you only show that they had a legitimate reason, but you can't rebut the non-discriminatory reason, or the discriminatory reason, you lose. So now, instead of having to prove what's called but for this reason, I would have kept my job, the plaintiff now has a more difficult burden in showing that the protected activity that they engaged in was either the predominant reason for the adverse employment action or that the legitimate reason itself is also a pretext. Makes it a little bit more tougher for people in Title VII now discrimination cases. So, we do a lot of this Title VII work in the office. It's probably about, depending upon the time, a quarter to a third, sometimes maybe 40% of what we're doing at any given time. Discrimination, sexual harassment, civil rights cases. Civil rights cases generally are under 1983, not Title VII. But it is fundamentally important in our society that those groups who often are less able to protect themselves have protection. Throughout the history of our country, the idea has been to protect minority groups against what Alexis de Tocqueville, a French philosopher, called the tyranny of the majority. The majority should not always be able to dictate. And that's what law is all about, trying to find out who's protected from what, and for that, very often, you need a lawyer, especially if you got legal papers in the mail or got served. So that's it for this Friday, Ask a Lawyer. Thank you for joining us. I hope that it's been interesting. I'll be back next Friday. And hey, give Cheryl a call at 781-8003 and have a great weekend. Bye-bye.
You've been listening to Ask a Lawyer right here on WPSL, Port St. Lucie, WPSL.com, worldwide, on Alexa and Google Home.
Only Alexa and Google Home?